Today we're going to look at some of the interesting contract law cases and one practical case on privilege which happened in 2022, which we thought had most relevance to those of you that deal with commercial contracts on a day-to-day basis. We're going to try and look at those by way of a quiz. And so just to explain the format, what we'll do is we'll start off with a fictitious scenario and then present what the legal issue is. And then there will be a pop-up of multiple choices so that you can test whether you know the correct answer. So the pop-up of the multiple choices will be by way of a poll. And then once we've got the results from the poll, we'll explain the correct answer and what the contract law development was. This is all anonymous, so you won't see each other's answers, so don't worry about getting it wrong. Just before we begin, and just by way of introduction, for those who haven't joined one of these before or haven't dealt with Abby or me, I'm a partner in the firm's dispute resolution practice based in London, and I'm joined today by Abby.
And I'm an associate, again, in our dispute resolution practice, based in Norwich, but obviously as a team we cover things nationally, so may have worked with you in other regions as well.
Fantastic. Just before we kick off, just a little bit of housekeeping. So the first point is the webinar is being recorded, so you'll be able to watch this later, or for those who aren't able to join, such as your colleagues who might like to join this, we'll try and send a recording of this afterwards so that they can view it. There is a Q&A function as well, so please feel free to ask questions about anything that we discussed during this. Again, the Q&A function is anonymous. I think we had about 450 people register for today, so we'll try and deal with as many questions as we can at the end. And if not, then we'll try and follow up with as many of you as possible afterwards. So if we kick off with the quiz, so the first question is about force majeure. And we've put the fictitious scenario there on the screen. So effectively, the scenario is that Chase enters into a contract for the supply of goods from an entity called Splash, and then then it subsequently occurs that Chase's parent company, which is a Russian entity, becomes subject of US sanctions. And that prevents Chase from being able to pay its liabilities under the contract in US dollars. And the contract has a term that the payments need to be made in US dollars. Chase tries to seek that there's a force majeure event, and the force majeure clause in question here has a provision that it's not possible to overcome the force majeure event by reasonable endeavours. So what would be the following position in terms of the options which are there on the screen? So I think my colleague Kate will open up the poll. Okay, so there's quite an even split there between the answers. So I think you might recall at the start of the COVID pandemic that there was quite a lot of discussion, certainly within sort of legal communities, around force majeure, and we all thought there'd be a whole host of cases which arose out of the pandemic about force majeure and its impact on force majeure clauses. However, what we've seen is there's actually been relatively few to date, and so the facts in this case arose from a case called MUR Shipping and RTI, which is there on the screen. And the issue arose from US sanctions rather than the pandemic. And so what happened in this case, just slightly changing the fact pattern around, is that the shipping company MUR wrote to the charterer RTI to say that it had seen that RTI's parent, which was a Russian entity, had been made subject of US sanctions and would therefore be unable to receive payment in US dollars, which was the payment under the contract, and therefore MUR declared a force majeure event so that it could stop preventing its services under the contract. RTI in this case had actually responded saying that it couldn't make the payment in dollars, but actually it could make the payment in euros, and that it would actually pay any exchange costs to MUR to make it whole. And MUR refused this and then refused to perform its obligations under the contract. So the question was whether MUR was entitled to claim the force majeure event, where effectively RTI had suggested an alternative way of performance. The force majeure provision in the contract was a fairly typical force majeure clause. There was no issue that the imposition of sanctions on RTI's parent was not an issue which was covered by the force majeure provision. However, the force majeure provision did state that a force majeure event could only be invoked where the relevant event or state of affairs could not be overcome by reasonable endeavours of the affected party. And so we came back to this question of whether MUR had failed to use reasonable endeavours by not accepting payment in euros. And so there was quite a long history in terms of determinations of this issue. So it first started off in arbitration, where the tribunal found that MUR had failed to use reasonable endeavours. That was then challenged to the High Court under the Arbitration Act, an appeal on a point of law, and the High Court actually found in MUR's favour, saying that the reasonable endeavours obligation in a force majeure clause doesn't require a party that invokes the clause to accept effectively non-contract performance to prevent the force majeure event. So put another way, MUR didn't have to accept something which was not part of the contract in order to get around the adverse effects that had been caused by the force majeure event. That was then appealed to the Court of Appeal, who overturned the first instance High Court decision. And it found that by RTI's offer to pay an equivalent amount in euros, which effectively matched the amount that MUR was to receive in dollars, RTI had found a way to perform its contractual obligations. And therefore, unless MUR could set out why it would suffer detriment not to accept euros, it had failed to use its reasonable endeavours to overcome the force majeure event. The judgment sort of stresses that each force majeure case is going to largely be looked at on a case-by-case basis, depending on the wording of the clause which is used. But it's interesting to those who draft contracts on a day-to-day basis and put in force majeure events, if you provide for certain steps within that clause of what a party needs to overcome in order for the force majeure event to be engaged. So if you have these reasonable endeavours clauses to overcome the force majeure event, you might just want to have a careful think about actually what are the issues that might arise, and just the potential non-contractual ways that your counterparty might offer to perform the contract to overcome that event. So just to explain what the correct answer there was, it is A. So 35% of you were correct. We'll move on to question 2.
Thanks, Mark. So question 2 concerns governing law and jurisdiction. In this scenario, we have a Belgian company, Allison, who bought foreign exchange market services from queenofhearts.com, which was another Belgian company with international operations. The director of Allison checked a box on Queen's website to confirm that Allison agreed to Queen's terms and conditions when entering the contract, but this director did not read the terms and conditions or click on the link to download them. Subsequently, a dispute arose between Allison and Queen about the fees due under the contract. In breach of a jurisdiction clause in the contract, Allison commenced proceedings in Belgium and sought to challenge the validity of the contract under Belgian law. The question we have for you is what options does Queen have? And apologies be on your screen shortly. I should say, if you can't see the full text of the potential answers, do hover your mouse over the 3 dots at the end of the last word and the full answer should show up. Okay, so I can see that the majority of people are going for C, although some people are obviously choosing the other options. C is the correct answer. The answer would be to issue a claim in the English courts and seek an anti-suit injunction. This case mirrors a recent case, the name of which is at the bottom of your slide there. Proceedings were issued, in this case, proceedings were issued by the defendant to the Belgian case. So proceedings were issued in England and they sought an anti-suit injunction to restrain those Belgian proceedings. It was argued that the anti-suit injunction shouldn't be granted because Article 10.2 of Rome 1 provides that Belgian law governs the question of the formation of the contract, and it was not possible to establish the high degree of probability that was required by Belgian law that the jurisdiction clause in the contract was properly incorporated. So Article 10 of Rome 1 provides that 1, the existence and validity of a contract or of any term of a contract will be determined by the law which would govern it under this regulation if the contract or term were valid. And the second part of that article says, nevertheless, a party, in order to establish that he did not consent, may rely on the law of the country in which he has his habitual residence. So if it appears from the circumstances that it would not be reasonable to determine the effect of his conduct in accordance with the law specified in the previous paragraph. So the effect of this was that in this case, the judge held it was not unreasonable to apply English law to the questions of incorporation and consent. Although the agreement was a transaction between 2 Belgian companies, both companies had international operations in different countries, and the subject matter of the contract in question had international elements, and the dispute itself concerned payments in connection with those international operations. So all in all, the transaction had a really significant international flavour and it wasn't purely domestic, so it couldn't be, it wasn't purely entirely unreasonable for a law other than Belgium to consider this claim. On that basis, the court found there were no strong reasons for declining to grant an anti-suit injunction. And interestingly, the court also found that the evidence of the Belgian law expert that was provided stated that the Belgian courts were likely to find that the English choice of law clause was invalid. And that in itself was another reason to grant the anti-suit injunction. So if we move on to question 3.
Perfect. Thank you, Abby. So question 3, this, for those who partake in fashion. So we've got a case here where there's an English entity called Ruby that designs and manufactures luxury clothing, and its French operations are operated through a French company, which it probably helps just to explain within the fact pattern I'll come on to on the John Lobb case there at the bottom of the screen, that effectively the French subsidiary is then sold to another clothing manufacturer. And so the parties enter into an agreement which basically records that the French entity is the sole owner of the legal and beneficial title in the portfolio of Ruby dresses throughout the world, and effectively how Ruby and Dorothy, the English and French entities, are permitted to use the marks. Sometime later, the English entity becomes aware that actually that it's the beneficial owner of the Ruby dresses trademarks globally, and that the parties have been mistaken when entering into the agreement. And so Ruby issues a claim asking for the court to render the agreement void from the outset on the basis of common mistake. So if we apply the test for common mistake, what is it that the court is likely to find on this fact pattern? So if we put up the poll, so effectively, is it that A, that as Ruby misunderstood the state of affairs, there's no common understanding recorded in the agreement, and therefore the agreement's void? Is it B, that by entering into the agreement, Ruby took the risk that Dorothy owned the trademarks and a claim for mistake cannot be made out? Or is it just simply C, that the agreement is impossible to perform, so is void? B is the front runner at the moment, although I keep on thinking A is going to make a comeback, but no, I think B is becoming the fundamental winner there, and the answers are starting to tail off. So we'll start to close the poll. So the correct answer is B. That by entering into the agreement on this fact pattern, that Ruby took the risk that Dorothy is the owner of the trademarks. And so basically the factual matrix of this slightly odd case came out of the case there on the screen called John Lobb. For those of you that are in the know and like their shoes, John Lobb is a high-end manufacturer of shoes. For anybody that's interested, if you Google Prince Charles and John Lobb, you'll see articles about a pair that Prince Charles was wearing for over 40 years. So it's they're pretty durable shoes as well. And so the case is slightly odd, that basically it transpired that neither party seemed to know who owned the IP to the John Lobb trademarks, and so it sort of really stemmed from a transaction back in 1976, where a family member of the John Lobb group had sold the French entity which it had to Hermes, and as part of that sold the trademark for John Lobb that was registered in France as part of that transaction. And then over the years they entered into new agreements, and it culminated in this agreement in 2008, where under that agreement the French entity agreed to assign any of the rights that it had in the John Lobb trademark in the UK to the English John Lobb entity, and that the French entity would effectively continue to protect the trademark for the benefit of the English entity. And the recitals had recorded that effectively the French entity had the right to the John Lobb trademark globally. It was only in 2020, so some 12 years later, that the English entity actually worked out that it was entitled to, well, certainly in its view, it was entitled to the beneficial ownership of all of the John Lobb trademark portfolio outside of France. And the French entity disagreed and said that, in any event, the 2008 agreement clearly demonstrated the English entity's acceptance that the French entity had legal and beneficial ownership of the entirety of the trademark portfolio. And so what the English entity did was it ran off to the English courts to argue that the 2008 agreement should be rendered void on the basis of common mistake about who owned the trademarks. And so the High Court picked this up on an appeal of a master's decision, where it struck out the English entity's claim that there was no common mistake. Basically, in order to sort of reach this conclusion, the judge looked at the 2008 agreement and said that on the basis of that and the recital recording who it was thought owned the trademark portfolio, that the English entity was unable to demonstrate that either the mistake rendered the performance of the 2008 agreement impossible, or rendered the subject matter to be essentially radically different from the subject matters which the parties believed to exist. And in reaching that decision, the court summarised that effectively there's no confusion in what is deemed to be the test for common mistake in a case called the Great Peace Shipping case. And so therefore the required elements, if you're going to argue common mistake, and I would certainly hope that common mistake cases are quite rare, and hopefully you will know what the state of affairs is when you're entering into a contract. But if you are going to argue common mistake, effectively the test is still that which is laid out in the Great Peace Shipping case, which is effectively you've got to establish that there's a common assumption between the parties as to the existence of the state of affairs, There's no warranty by either party as to the state of affairs that exists. The non-existence of the state of affairs is neither party's fault. The mistaken state of affairs renders contract performance impossible, and that the state of affairs may be fundamental to the contract's consideration or to the circumstances which are necessary for performance. I think what's quite interesting about the case, certainly for those of you that deal with contracts on a day-to-day basis and are drafting them, is the importance that was placed on the recitals in this case. I think sometimes, parties skip over the importance sometimes of recitals, given that it's not an operative clause of an agreement. So it is a good reminder just to take care that the recitals are correct and actually demonstrate what is the position between the parties. So I think we can move on to question 4 now, Abby.
Thank you. So this question concerns interpretation. And as you can see on the slide, our next scenario deals with, so in January 2017, Mr. Mole entered into an agreement with Mr. Toad to build an extension to Toad Hall. This first agreement, stipulated that Mr. Mole would be paid hourly rates for his services. Subsequently, they entered into a second agreement, which confirmed, as set out on the slide, we have agreed that Mr. Mole will charge Mr. Toad a fixed fee of £300,000 for the services plus disbursements in connection with this matter, subject to the completion of the matter by the 31st of May. Unfortunately, the extension wasn't completed by the 31st of May, but Mr. Mole continued to work, and in June, July of that year, he asked for payments of his invoices by Mr. Toad. Mr. Toad tried to withhold payment of those invoices on the basis that the second agreement meant if the extension was not completed by the 31st of May, he would not have to pay anything. Mr. Mole disagreed and said that the condition only applied to the fixed fee element of their agreement, i.e. that Mr. Toad would be liable for the £300,000 if the extension was completed by the 31st of May, but if it wasn't, Mr. Toad would be liable for more. So here we're asking you to give an indication of what you think the correct answer is. Is it, the poll should show up on your screen shortly. So is it A, was Mr. Toad correct and therefore only liable for £300,000? Was it B, that Mr. Mole was entitled to payment of all of his invoices? Or C, was the contract void for lack of agreement? It's a relatively even split between the answers right now. It's interesting, people are generally split between A and B. So if I reveal the answer, and the answer is actually B, the court found that in a similar case, that the full amount was payable. So this case is similar to that which is on your screen, a case of Black Lion law. And this case is a useful reminder of the importance of using business common sense in contractual interpretation, where the contract clause in question is open to multiple interpretations. This Black Lion law case concerned a commercial relationship and the retainers between a law firm and its clients. In this case, the judge held that the clause, that there was a similar clause as that on the screen in the retainer in question. And the judge held that it was unclear which parts of the clause the words subject to related to. And so the judge considered the context in which the second agreement was entered into. In the circumstances, the judge found that the law firm's construction was far more consistent with business common sense, as one, from the first agreement, the client was aware of the approximate hourly rate by which the law firm would provide its services, and therefore approximately what the law firm would expect to charge for the work in question. 2, it was unlikely that the law firm in question would be prepared to tie up a large proportion of its available resource on a project and to only be paid if it was successful. And 3, that it made no commercial sense for the law firm to agree to be paid a fee worth far less than the work done on a project if the matter was completed by the deadline, and nothing at all if it didn't. It made better business sense to construe the fee agreement to entitle the law firm to be paid the fixed fee, regardless of whether or not the matter completed by the deadline, and to charge separately for the work done after that date. So it is a bit of a cautionary tale to avoid finding yourself in a position where you need to fight about whether or not your fees are payable, but it is also interesting to note and sort of reassuring that the court will apply business common sense here. Then moving on to the next question, which is question 5. Thank you. This question deals with novation. And again, moving on to our next scenario. In this scenario, Big Bad Wolf Limited entered into a contract with Pig One Limited for services. This contract contains a clause which provided that this contract shall commence from the date of this agreement and shall continue until such time as either party gives the other not less than 3 months' notice in writing of termination. So, following an internal corporate restructure of the Three Little Pigs group, Pig 2 then began providing Wolf the services under the contract and invoicing Wolf the relevant fees. The question we're asking you to consider here is, was this informal novation from Pig 1 to Pig 2 successful? And your potential answers are on the slide there and should show up on the poll shortly. Your options are A, no, the termination provisions of this contract mean that formal notice was required for the novation to be effective. B, yes, this termination clause had no effect on novation. Or C, yes, because termination provisions never have any effect on whether or not you can novate a contract. There's one particular answer storming ahead before the other ones. Maybe that the answers are starting to tail off now. So I will reveal the answer for you. 43% of you have it right. It is B. Yes, this particular termination clause had no effect on novation. This came up in a recent case, and the name of which is at the bottom of your screen, and I won't attempt to try and read it out to you. This case, the Gamma Aviation case, concerned a similar fact pattern, and the High Court considered whether the clause on your screen prevented the informal novation from taking place. So, as a general rule, where a contract expressly specifies formality for its variation or termination, any such variation or termination that doesn't comply with those formalities will be ineffective. And this was a matter discussed by the Supreme Court in Rock Advertising in 2018. As a novation involves the termination of a contract in question and the entering into of a new contract on the same terms with different parties, this termination provision set out on the slide was considered by the court. The judge in this case found that this termination clause related to unilateral termination only. As such, it had no bearing on whether or not mutual termination was available. As the contract was silent with regard to mutual termination, it contained no requirements as to how the parties could bring about the formalities for mutual termination. And therefore, on this basis, the informal novation had been successful. So what's the takeaway from this particular case for you? It is to consider if a novation is to take place, what formalities are required under the contract, and to ensure, so far as there are any, that they are complied with to avoid falling into the position where you have a dispute such as this. So we have question number 6.
Perfect. Thank you, Abby. So here we go. We've got the parties here from a favourite Disney movie. So we've got Cinderella here entering into agreement to sell pumpkins with Fairy Godmother, and it's not too sure about Fairy Godmother's credit worthiness. And so basically to facilitate the transaction, Prince Charming issues an irrevocable letter of credit in favour of Cinderella as the beneficiary. And so the letter of credit incorporates standard industry terms which are contained in the ICC's Uniform Customs and Practice for Documentary Credit 600, also known as UCP 600, and they're provisions which are commonly adopted in letter of credit transactions. And so Cinderella provides Prince Charming with the documents that are required under the letter of credit. And when Fairy Godmother fails to pay for the products that have been supplied, seeks to immediate payment from Prince Charming under the letter of credit. Prince Charming, as the issuing bank, turns round and refuses to pay out on the letter of credit, arguing that the UCP 600 terms have been modified and overridden by its own credit norms. And as such, the documents which Cinderella has provided for the letter of credit are insufficient. So the question here really revolves around the amendment of standard industry terms which are adopted by parties in contracts. And so basically the question is, can Prince Charming refuse to pay Cinderella? I think if we pop up the poll, please. Perfect. So the questions are that yes, they can modify and override Prince Charming's own credit norms. So the UCP 600 can be modified by Prince Charming's own credit norms. The answer is no. It can be overridden by Prince Charming's credit norms. And then the classic lawyer end question there, answer of it depends, which I think is going to be the clear winner on the poll here. And so the reason for C, just for those who can't see the language, is that it depends, because if the LC provides that clear wording to show an intention to depart from the UCP 600, they will always be able to do so, or otherwise the UCP 600 terms will apply. So I think on the basis that we've got a clear winner here, I think if we just stop the poll now, that the correct answer is C. And so, as I said, this case derives from industry terms or codes which form the basis of contractual agreements by parties. They're certainly common in letter of credit transactions, which are very often sort of fast-paced, high-volume contracts, where the parties seek to say that the standard industry terms, in this case in the UCP 600, apply. I should just say there's been a recent spate of cases recently around letters of credit where, and certainly what we've seen from clients as well, is that there have been various instances of issuing banks trying to sort of get out of paying under letters of credit. I think it's probably the environment that we're in at the moment, just given the pressures in the global market. And so the fact pattern there of the Cinderella Prince Charming case came from a case called Haytex and Unity Trade Capital, which is there at the bottom of the screen. And so in this case, in disputing the letter of credit, the issuing bank, Unity Trade Credit, tried to argue that its own credit norms were incorporated into the letter of credit, and that those norms prevailed over the terms of the UCP 600. And this went all the way to a hearing where the court had to consider this argument, and effectively the court rejected the argument. I think what was quite interesting, though, was actually that the court looked at the UCP 600 and found that the whole regime of letters of credit and the standard form contracts benefit from the remarkable degree of international standardization due to the widespread adoption of the UCP 600 rules globally. And therefore, if you are going to try and depart from any terms within the UCP 600, you're going to have to expressly require in your letter of credit effectively the clearest wording to evidence that you are deriving away from the standard form terms within UCP 600. So it's not a particularly surprising decision, but we just thought it was interesting for those who are in commercial departments that work with contracts where you adopt standard industry terms as part of your contract, and certainly for those of you that deal with letters of credit on a day-to-day basis, just to be aware of this case. So again, the correct answer there was C. So I think we'll have to work harder on an suggested answers for next year. Move on to question 7.
Thank you. This is our last question, and it concerns internal investigations and privilege. As you'll see, the scenario for this one is relatively short and sweet. Mr. Peter Pan was authorised to instruct solicitors on behalf of Neverland Limited to obtain advice on its legal position in respect of certain litigation. What we're asking you to consider here is, was Mr. Peter Pan's identity privileged? The poll should arrive on your screen shortly, and the potential answers for you to select are either A, yes, the identity of those giving instructions to solicitors are always privileged, or B, no, the identity of those instructing solicitors are never privileged, or again, C, it depends, only in certain circumstances will the details of those giving instructions be privileged. As you'd expect, for an in-house forum, lots of people are choosing the lawyer it depends answer again. I think it's fair to stop the poll as we have a very clear winner. Again, C, depends, that's the correct answer. This was considered in the recent case, again, the name of which is on your screen, of Law Relief Financing and Credit Suisse. So in this case, it was argued that the identity of those authorised to give instructions to solicitors on behalf of a corporate client in the course of litigation is covered by litigation privilege, as it falls within a zone of privacy established by the privilege. And it's not necessary to show that whether privilege would be undermined by disclosure. It's not necessary to show that privilege would be undermined by the disclosure of that identity in order to withhold disclosure of that identity. So the court eventually got to the Court of Appeal, and the Court of Appeal rejected those arguments and emphasised that privilege attaches to communications rather than information or the facts divorced from those communications. As such, there's no general principle that the identity of those giving instructions to a lawyer for the purposes of litigation will be protected, and each claim for privilege will be considered on its own merits. There would be an exception to this where the disclosure of the relevant individual's identity would prevent candid discussions between the lawyer and client, and therefore affect the client's ability to prepare its case. For example, because revealing such information could give away something about the content of the communication with the lawyer or the litigation strategy being discussed. But as I said, claims for such privilege will be considered on a case-by-case basis, and there is no general rule that identity should be protected in that way. So that.
Perfect. Thanks, Abby. So that's been a very quick canter through just some of the developments that we thought would be of interest for, especially for in-house teams and those that deal with commercial contracts. Just conscious of time, that we usually tend to wrap these up at around 10:45. Just on questions that have been put on the Q&A function. There's a question just about the John Lobb case, and whether the position would be any different if there was a clause which stated or warranted that the party granting the rights had ownership of the rights in the first place. And yeah, I think the question is, sorry, the answer is yes. I don't think you would bring that case as a common mistake case. Effectively, I think what you'd be looking for is probably a breach of warranty type case, or a misrepresentation case in that scenario, in order to try and get out of performing your contractual rights under the agreement. So it might be, if there's something of fundamental importance of the understanding of the parties when entering into the contract, you could always provide for that by way of a warranty from the other party to confirm that that is true. Just very conscious of time. There's just a question here just about lessons learned through the pandemic on force majeure clauses. Again, the force majeure clauses didn't arise that often before the pandemic, and there were certainly lots of arguments at the start of the pandemic. I think what I sort of principally found where a lot of parties were arguing force majeure at the start of the pandemic was that they hadn't really addressed the question of, in order for a force majeure event to be engaged and to effectively excuse your performance under the contract, depending on the word of your force majeure clause, it will usually either have render performance impossible or hinders performance or prevents performance. And I think actually when you debated with the other side, actually whether the effect of the pandemic impacted the ability to perform the contract, or did it just make it more expensive to perform because of lack of staff around, etc., issues like that. Is it actually the pandemic which is the force majeure event creating the hardship to you? And the answer was often no. So I think that's certainly what we were finding at the start of the pandemic. I'm sure for those of you that are dealing in with commercial contracts on a day-to-day basis, you've got your own sort of war stories from the start of the pandemic on that as well. Again, I'm just conscious of time, so I think we'll wrap up there. Thank you very much for joining today. I hope you enjoyed it. We certainly had sort of a lot of participants today, so we'd be delighted to hear sort of your feedback from today. Hopefully there'll be a pop-up after this webinar as well. Please do let us know if there are any particular topics that you would like to hear more about. As we're trying to provide these for you on sort of who are dealing with commercial contracts on a day-to-day basis. So if there is legal issues out there that you would like to hear more about, then please do let us know by completing the survey once this webinar ends. I think I'd just like to say thank you very much for joining the first in-house in focus of 2024, and happy new year to everybody. Thank you very much.